Dave mentioned, my name is Larry Ward, and I'm a partner at Dorsey & Whitney in Seattle. This is actually my second presentation today. I presented at my son's school earlier to a group of fourth graders, and I can tell you that they actually asked really tough questions in my presentation, so I'm expecting good questions from this audience as well. An area that is very closely related to export control regulations are the OFAC economic sanctions. And these have really been in the news over the last year because there have been a lot of developments with these regulations, particularly as to four countries. There have been a lot of changes as to Cuba. There have been a lot of changes as to Iran. There have been a lot of changes as to Russia. And there's also been a lot of changes as to China, although they're not sort of as explicit as they are as to those other three countries. The goal of today's presentation is to really just sort of give you an overview of these sanctions regulations. It's certainly not to make you an expert in any of these regulations, and just to give you an idea of how they would impact defense exporters, particularly because the news media does not do a very good job at sort of explaining the changes that have been going on. For some people, we have clients that will come to us and they read a news headline that makes it look like you can now do all business with Cuba, or you can now do all business with Iran. And to be honest, that nothing could be really further from the truth. There have been some windows opening in both of those countries that do allow certain U.S. exporters to either do something because it's on the face of the regulations, or to still apply to the U.S. government to get a license to do it. So there's some very small windows of opportunity for U.S. companies. So this is really just to give you an indication of sort of the red flags that you need to raise if these countries ever come up. The sanctions regulations have a little bit of a different impact or sort of policy behind them. When Adam was talking about the EAR and the ITAR, those regulations are very concerned with U.S. national security. They're very concerned with defense exports in particular, and they're very concerned with protecting U.S. soldiers abroad. And so that's really the reason why we have those regulations in place. Increasingly, especially the EAR is also protecting things on the homeland security side. And so they sort of come at it with a little bit different philosophical or policy approach. The sanctions really are focused on foreign policy as to relations that we have with other countries, although they also do have some impact on U.S. national security as well, because a lot of these regulations are really focused on terrorism. They're focused on weapons of nuclear weapons and preventing proliferation of those weapons. So these regulations really do have an impact on defense and defense companies as well. They've really been around since the beginning of the country. It wasn't until the 1950s, though, when the Office of Foreign Assets Control, which is always referred to as OFAC for short, actually came into being. And that office actually sits within the U.S. Department of the Treasury, which makes sense if you sort of step back and think about it. These are economic sanctions, so they're focused on the economy with a particular country or a particular group. And so that's why OFAC sits within the Treasury Department. Historically, our sanctions on other countries were really just developed with U.S. foreign policy in mind. We didn't really consult with other countries. We didn't really care what other countries had to say about how we view Cuba or how we view another country. That is becoming increasingly rare, though. As the world becomes more global, U.S. foreign policy really is hand in hand with what the UN Security Council is also wanting to do. And it's not to say that the U.S. doesn't stray from what the UN Security Council wants to do if it feels that it needs to protect its own foreign policy positions. But in general, the U.S. government really does try to work with its allies to ensure that we're sort of all acting on the same page as to particular countries. These sanctions regulations deal with all U.S. origin goods and services. So as Adam was talking about before with the USML and the CCL and you having to research those lists to figure out whether your products or your technology falls on one of those lists. When it comes to these regulations, they don't care if you manufacture a high-tech laser, they don't care if you manufacture a drone, they don't care if you manufacture a widget or a nut or a bolt, okay? They simply just care that you manufacture anything or that you're going to export anything, and they prohibit exports of all U.S. origin goods and related services. So basically they're saying it's off limits as to these particular countries or groups or individuals. Currently, we do have major trade embargoes in place with a group of countries. These major trade embargoes, really, they are what they sound like. Basically, these entire countries are off limits when it comes to U.S. goods and services being exported to them. There are certainly some carve-outs and things that you can do, but as to the countries of Cuba, Iran, Sudan, and Syria, those countries are entirely off limits for U.S. exporters, again, with some minor carve-outs. One that is not in this list, because OFAC does not have a total trade embargo on it, but BIS does, so it effectively acts as a total embargo, is North Korea. So that one's not up on this list, but North Korea is also off limits. And then the last one, the United States does not recognize Crimea as a separate country, so we refer to it as a region instead. And so the region of Crimea is also under a total embargo from the U.S. perspective. There's also a host of other countries up there where there are limited sanctions, and I've listed those all out there. Really, the one that I think over the last couple years has become most important is as to Russia. And particularly with respect to the Russian oil and gas sectors, because that's really what is targeted under that set of regulations. The Russians are also very savvy when it comes to these sanctions regulations. The U.S. has targeted certain groups and individuals and certain companies, certain financial institutions in Russia, and when you sort of step back and look at the Russian economy, they refer to them as oligarchs. Those oligarchs tend to not only own those businesses that are directly targeted by U.S. sanctions, but they tend to own a whole lot else as well. And so it's really tough when you're talking about Russia to peel back the onion and really figure out, okay, this company that I'm working with in Russia, is this a legitimate company that I should be doing business with, or is it a company that's owned by one of these oligarchs that I really should be careful and I probably shouldn't be doing business with? So when it comes to Russia, that's one country in particular that U.S. businesses really should be very savvy when it comes to figuring out who their partners are. And if you've got any doubt in your mind as to who the Russian company is that you're trying to work with, there's probably some good reasons why you might not want to actually engage with them. These sanctions also focus on targeting groups and individuals that focus on terrorism, focus on acquiring nuclear weapons. And within the last year and a half, the other big target of these sanctions programs has become cyber terrorism. And Adam referred to surreptitious listening under the ear. Cyber terrorism under the ear and under the ITAR and under these OFAC regulations is, within the next 20 years, that's really going to be the focus of all of these regulations, because that is where terrorism is headed. And so these sanctions regulations came about over the Sony incident that was in the news over the last 2 years or so, where a group of North Koreans had hacked into Sony's system. And when you, again, sort of peel back the onion to figure out, okay, well, how did North Korea possibly get the technology to hack into Sony's system when North Korea does not have very good technology? At the end of the day, it was China that was obviously helping the North Koreans and certain companies and individuals in China that were doing it. And so these cyber terrorism sanctions, although they don't specifically call out China, that is really where these cyber terrorism sanctions are directed. And so the individuals and entities that are added as targeted parties under those sanctions tend to all be from China. I've sort of been over this in the earlier discussion, that basically these sanctions laws mean that you can't export any goods or services to these countries groups or individuals. Skipping down to the very end, though, I wanted to talk about the second to last bullet point. Oftentimes, U.S. companies know that they can't do business with this list of countries, and so they're not going to make a direct export to Cuba, or they're not going to make a direct export to Iran. However, those U.S. companies will often have opportunities with foreign partners, where their foreign partner is in a country where they can completely do trade with Cuba. They can trade with Iran all that they want. And so oftentimes those foreign partners will ask U.S. companies, hey, we'd like your help in this part of our work with Iran, or this part of our work with Cuba, and we'd like you to provide us with X, Y, and Z, whether it be goods or services, to help in that opportunity with your foreign partner. And that is something that's called facilitation. So basically, if you're a U.S. person and you cannot do something with a particular country, you can't work with a foreign partner, or if you have a foreign subsidiary, you can't work with your foreign subsidiary to go ahead and take on some opportunity that you couldn't otherwise as a U.S. person. And so I think increasingly that's really where we're seeing U.S. companies get in trouble under these sanctions regulations. It's not because they're directly making exports to Cuba or Iran, but it's instead because they have an opportunity with a company in the UAE, for example, or they have an opportunity with a company in China, and at the end of the day, that opportunity is to supply goods into Iran. And so that's where U.S. companies really need to do their due diligence to figure out, okay, this foreign partner I'm working with, ultimately, what are they trying to accomplish through that transaction? There are carve-outs under these sanctions regulations. I've listed out some of them there. There are some pretty nuanced ones in particular sectors. So agriculture, humanitarian reasons, those are sort of other reasons where you can sort of drill down into the regulations and figure out whether or not you might be able to do something, whether the U.S. has sort of recognized that it's okay for U.S. companies to supply food, for example, into a particular country. And the intent of these regulations is never to harm the ordinary citizens in these countries. Unfortunately, it often has that impact. So the U.S. government has implemented some carve-outs into these sanctions so that if you are trying to do something for a humanitarian purpose, then it generally tends to be allowed under these regulations. The other really big one that the U.S. government has allowed over the last few years is telecommunications services. U.S. telecommunications companies, internet providers, being able to supply their goods and services into these sanctioned countries. You all are likely familiar with the Arab Spring that happened several years back. There were several countries that were involved in the Arab Spring where the U.S. had sanctions against those countries. And really, what the U.S. government found was sort of the best way to topple those regimes was to allow the citizens in those countries to have Twitter, to have Facebook, to post videos onto YouTube, and to allow them access to that software, allow them access to mobile devices, and effectively that led to regimes toppling throughout the Arab Spring. So more and more the U.S. government is allowing that sort of thing with respect to Iran and with respect to Cuba in particular. That's been a big change over the last year, is that the U.S. government is now allowing telecommunications companies to go into Cuba and to really allow that regime change to happen through the people rather than having the U.S. government come in and try to sort of take over the country. These are just some key compliance questions to keep in mind if you ever happen to be dealing with any of these countries. Again, I'd indicated that U.S. companies tend not to get themselves into trouble for making direct exports to Cuba or Iran, but it's really when they're working with a third country partner. So if you're working with any company in the Middle East, for example, if you're working with any company in the former Soviet bloc, if you're working with any company in any of the STAN countries, okay, those are all countries where if you have partners in them, OFAC should really be a concern. It should be really top of mind for you because it's very possible that there's a diversion risk that these things are going to end up in Iran.
Sorry.
Yeah.
One quick question. So do you have let's say, working with a company in Europe that may have business trade with one of these OFAC countries, what's the responsibility to vet that out? I mean, are you supposed to, how far are you supposed to go as a corporation regulation?
Sure.
Whether that's just asking the company, or are you supposed to vet it out, or is there some amount of due diligence as expected on your side?
Sure. Yeah. So the OFAC at least has a standard of know or should have known, and so if you have when you're talking about a partner in the EU, for example, the EU, with the exception of Cuba, the EU basically follows everything that the US follows. So when you're talking about Iran, the EU is basically also agreed that Iran is off limits. When you're talking about the Russian opportunities, actually the EU is more restrictive than the US right now. So for the most part, when you're talking about the EU, there's not so many worries. It's really Asia Pacific where there really are pretty huge differences. But to answer your question directly, it's that know or should have known standard. So if you know that your partner is supplying into one of those countries, then it's certainly a concern. Or if you should have known. So if in your talks with your business partner, they're indicating to you that this opportunity is for sales all throughout Europe, they give you good background information to indicate that that's correct, then certainly I think you've sort of done your due diligence. You don't really need to drive down much further. If they start to put up roadblocks where they don't want to tell you what it is that they're doing with these items, there might be good reason for that. Obviously, they might want to protect some sort of trade secret. But at that point, if they are putting up these roadblocks to sort of limit your knowledge of where these things are going, that's when you really should drill down into some questions of, can you confirm that these aren't going to any countries on this list, and provide them with a list of countries, for example. But it's really sort of once you realize you don't have enough information into the end use and the end user of the items, that's when you should start to ask some questions, just so you can get comfortable that whatever roadblocks they're putting up are for legitimate business reasons, as opposed to there might be some diversion risk. Yeah. And I mentioned these were sort of the main countries where there have been a lot of changes over the last 2-3 years. With respect to Cuba and Iran in particular, we'll go into them in a little bit more detail later today. But just to highlight real quickly on Cuba, there's sort of been two purposes behind, well, there's a host of purposes, but the sort of biggest impact when it comes to Cuba, the Cuban sanctions, has been on tourism and has also been on agricultural goods. And so those sort of two foci of the Cuban sanctions are still in place. So U.S. tourism is still totally off limits as to Cuba, despite what you may hear. There's certainly a lot of categories of travel that have opened up and are allowing U.S. people to go to Cuba. But tourism, strict tourism, is still totally off limits, which is interesting. I'll talk a little bit more about that later today. And then agriculture. Really the biggest export that Cuba could make is sugarcane. And so the U.S. government has still ensured that the regulations as to U.S. companies engaging in the agricultural sector in Cuba are still pretty tight. With respect to Iran, quite frankly, there hasn't been that much change as to U.S. persons and what they can do with Iran. The biggest thing I think that was announced within the last year was that OFAC now has a favorable licensing policy when it comes to commercial aircraft. And so I know a couple of you mentioned that you're suppliers to Boeing. Boeing has made a pretty huge sale with Iran when it comes to commercial aircraft, and Boeing is going to be asking their suppliers to supply parts for those aircraft that are going to be supplied into Iran. There's not a blanket, go ahead and provide whatever the heck you want to Iran when it comes to aircraft parts. There is it's a licensing policy that effectively, if you are going to be exporting to commercial or civilian aircraft in Iran, your partner on the other side isn't going to be warehousing those items. So in other words, they're going to be using them immediately. And your partner in Iran is truly a commercial airline. It's not tied into the Iranian government. Then you will be able to get a license from OFAC to make those exports. Preparing those license applications, tricky. So if you've never prepared a license application like that before, you should definitely seek outside advice on that. But that is an opportunity, particularly for companies in the Puget Sound area that really do supply Boeing. We have one client that has sold to Iran Air under a license from OFAC for the last year or so, and sort of knows how to do things with respect to Iran. And so that's going to be a really great business opportunity for that company. And at the end of the day, they're sort of working with reputable companies like Boeing and Airbus. And so it's, you sort of don't have that bad feeling of working with Iran. You're sort of working for a good intent. With respect to Russia, Ukraine, and Crimea, really the focus there has been oil and gas. And so I think I heard one person mention doing work in the oil and gas sector. That is really the biggest concern when it comes to those countries. The cyber sanctions, again, the real intent there is China. And so if you happen to be engaging with one of these parties that's targeted under these sanctions, you can't, or if you have an opportunity to engage with one of those entities, you can't. There's a list that OFAC maintains. It's called a Specially Designated Nationals list. It's on their website. Every company should be doing prohibited persons screening. If you're not, if you're engaging in international sales, if you're not doing prohibited persons screening, you should be. That should be a central part of your compliance program. And ensuring that you check OFAC's SDN list is critical to make sure that you're not working with a potential partner that is targeted under these regs. The EAR and the ITAR both have some related pieces that tie into the economic sanctions, and I just wanted to mention them here. On the BIS side, the BIS maintains 3 lists that are similar to the SDN list. So these are lists where you basically can't do business with anybody that's on these lists. There's the denied persons list, the entity list, and the unverified list. And so again, that screening is critical in an export compliance program. A lot of companies, bigger companies in particular, are able to afford commercial screening software. They're able to integrate it seamlessly into their system. And so they're able to do a great job. Basically, anytime they get an inquiry or an RFP from a client, they're just able to enter in that name, and they're able to run a comprehensive list check. And so they run all the US lists. They also run all the EU lists and the Asia Pacific lists as well. And if there's any hits, they're able to sort of examine whether or not they should continue to do business with that particular entity. For smaller companies and medium-sized companies, sometimes affording that commercial software can be difficult. There are some really great products out there that are rather inexpensive, so I would encourage smaller companies to look into those if you don't already have one. You can run all of these checks manually, and the U.S. government does maintain a comprehensive list on a website, export.gov. The problem with those, though, is that the problem with doing it manually, though, is that you have to keep your records and you have to maintain your records and you have to make sure you're doing the screening correctly. So if you type in a name wrong, you're going to get the wrong results. So you're very limited if you do it manually. My strong recommendation to clients is always to get commercial software to do this for you. And again, just integrate it seamlessly into an invoicing process or whatever.
Is the use of one of those commercial applications considered adequate due diligence?
Not necessarily, no. So those commercial screening lists will oftentimes come back with sort of a who knows result. And so if you get a who knows result, that means that you are going to have to drill down into it further. You're going to have to figure out, okay, could this partner potentially be the individual or entity that's on the list? So it really just depends on the result you get back. If your result gets back that they're totally clean and the search has been done correctly, then that should be sufficient. Unless, of course, you have knowledge, or you should have knowledge that it's going to be going to somebody that it shouldn't be. And likewise, if you get a result back that says this is a hit, this is somebody you shouldn't work with, then again, that's kind of a good result. It's really that sort of middle area where you get a result back that's not clear, that you really do have to do further due diligence.
What if you get one of those like big pop buildings, it's so where it's the same address but a different floor in China or something?
So that's one of those where you really do have to just drill down and examine examine it. And you know, we always recommend to sort of ask the questions to your foreign partner, figure out you know, what you can about that foreign partner, see how comfortable you are with that foreign partner, that they're answering truthfully. Sometimes having them sign a certification that indicates that you know they're not this entity with you know a similar address or whatnot can be helpful. The other thing you can do, we sort of recommend this as sort of a last step, and we also recommend ensuring that you do it through legal counsel. You can also interact with OFAC or with BIS or with GDTC if it's on the ITAR side of things. But the reason why we always suggest that you get legal counsel is because if you've done something wrong already, you don't want to just start admitting things. Apologies to Adam, but you don't want to just start admitting things, and I know Diane and others from Commerce Department are in here, but you don't want to start admitting things to the government unless you've fully fleshed out that you haven't done anything wrong yet. But at the same time, those U.S. government agencies can really be a good help. And you know, if you haven't done anything wrong yet, contacting OFAC, contacting BIS and saying, hey, we've got a hit that it's a similar address, it's a different suite number, what do you happen to know about this particular address? In some instances, they might say, yeah, that whole building is owned by the same entity, and you know, you should treat them as an SDN. Or they might say, no, that's a large, you know, 100-floor building in China, and you know, that's a different suite. We don't consider it to be related. So you can certainly get that advice from the government. We just recommend that you be educated about how you go about getting that advice first. And the other couple things that BIS has that are, I think, very useful in this area are the Know Your Customer guidance, and I'm not going to read through it. This is just basically directly from the ear. And the red flag indicators, and I've just included those in here as well. Again, they're part of the ear. So those are just ear tools that are very closely related to these sanctions issues. And this is just an example of the ear's entity list entries. On the ITAR side of things, the DDTC has its own, what they refer to as a policy of denial. So they don't really refer to them as an embargo, but these are countries that you cannot make defense exports to. The U.S. government is not going to issue you a license to make defense exports into these countries. And so I've listed them out there. Really the biggest one is China, because that is the one where U.S. companies tend to have opportunities. That other list of countries up there aren't ones where U.S. companies tend to be particularly interested in heading. And then the last thing that I wanted to, I believe it's the last, yeah, the last thing that I wanted to make mention of here was that OFAC has a process, a very well outlined process for when you've done something wrong. They have what are called penalty guidelines. It's part of the federal regulations, CFR, and it basically talks about if you've done something wrong, if you just voluntarily disclose it to OFAC, here's the credit that you're going to get. So in other words, they're going to cut that penalty that you could potentially owe. And then they also list out a whole host of mitigating and aggravating factors. So if you've done X, Y, and Z to mitigate what you've done, they'll give you credit for that. Likewise, if you've done A, B, and C, you might get additional penalties because you've done something else wrong. But OFAC has very, very clear guidelines when it comes to penalties, when it comes to disclosing these things to the U.S. government. The BIS and the DDTC have not been as good about what happens when you've done something wrong and telling U.S. businesses what exactly they should be doing and how exactly the U.S. government is going to be viewing it. Both of those agencies, BIS and DDTC, are currently in the process of revamping their systems. And BIS just put out a Federal Register notice within the last, it's 2 months or so, where BIS is basically adopting OFAC system entirely, or they want to adopt OFAC system entirely for violations, so that it's a lot clearer what's going to happen to you. The tough thing with BIS, they have the Office of Export Enforcement, where they actually have criminal enforcement power. And so you could actually go to jail for violating the EAR, which is a little bit different. On the ITAR side of things, DDTC doesn't have that power. They actually have to get it through the Department of Justice. But with respect to BIS, they've had that power. And so it's always been a little bit scary for companies when they do violate the EAR, what exactly they do. They don't know how BIS is going to handle it. They don't know if they could potentially end up with criminal penalties. And that's not been BIS's intent. You know, certainly if you're making exports to Iran that you shouldn't be for nuclear weapons purposes or biological or chemical weapons purposes, they're not going to be real happy about it. But if you've just done something by accident, BIS doesn't want you to be fearful of disclosing it to them. So BIS is coming out with these guidelines that closely mirror OFAC's guidelines. So taking a look at the OFAC guidelines, figuring out sort of how the EAR is going to change when it comes to penalties. And then DDTC is doing something as well. It's not going to be exact with respect to the OFAC penalty guidelines, but they're taking a lot of influence from those guidelines as well. And that is the end of my presentation. I think I've gotten a little, try to keep us at least a little close to time. Are there any questions that anybody has?
Oh, okay. Subcontractors. Okay, so we have a subcontractor who drops a bomb on us and says, we've done business with a denied party. Whammo, we already disclosed it to DDTC. That component's already been integrated into your product. It's already been exported. And we went through all this with DDTC, so we had to do a quickie voluntary disclosure right away. And just kind of follow up on what you said. Because we did that, we had a compliance program. They got fined, but we didn't.
Mm-hmm.
But it's kind of scary when you have lots of subcontractors that may not have really, they're not screening.
Right.
And they've already put this into your product, and it's like tag, you're in, you know. It was pretty nerve-wracking to go through that investigation. But anyway, voluntary disclosure, I just want to say, was the way to go immediately.
Yeah. We always, well, I shouldn't say we always, but I would say pretty close to 100% of the time we do recommend voluntarily disclosing something to the government. Sometimes there are business reasons why making a disclosure doesn't make sense. But you know, we do typically recommend that voluntary self-disclosure. The other thing that we would recommend to clients is to interact and engage with the government agencies when they ask for your help, because that can be a great mitigating way if you ever happen to do something wrong yourself. So we do have another client right now that they have done something wrong, and we've disclosed that to the government that they've done something wrong. At the same time, another government agency has sort of asked them to make particular advances with an individual to sort of help in their own investigation. And so that sort of help to the U.S. government will hopefully maybe not get them off the hook entirely for what they've done wrong, but the U.S. government certainly will consider it to be a great mitigating way. And you're right. I mean, these agencies, again, if it's not something that's going directly at U.S. national security, protecting soldiers, they do tend to be pretty forgiving, especially if it was accidental. If it were accidental, you know, we'd certainly, you know, recommend there's absolutely no reason why you wouldn't want to disclose it.
Can I do one more follow-up?
Yeah.
Okay, we have NDAs with all our suppliers and so forth. We were kind of disappointed in this one that they did not contact us or even give us a heads up when they just hit us with this notice, you know, after our product was exported. You know, I mean, the cat's out of the bag. It's too late to stop it. And we were really disappointed. I mean, do you recommend, I mean, before someone gives a voluntary disclosure and there's other affected third parties that are going to be impacted by this, wouldn't it be a good idea, even though we're covered by an NDA? I mean, what's your feeling on that?
So that's tricky.
I mean, they're not going to talk us out of it.
No. So The U.S. government gives you credit if it's a voluntary self-disclosure. So if you go into them first, on OFAC, they immediately knock off half of the base penalty. So if your base penalty is $1 million, immediately it goes down to $500,000 just because you voluntarily self-disclosed it to the government. And then it can go down further from there, just depending on a host of other factors. If you don't voluntarily self-disclose it to the government, though, then you don't get that credit. So you're still starting at $1 million. Voluntary really means that. It means that you have disclosed it to the government. It does not mean that OEE or Office of Export Enforcement let OFAC know, and then you let OFAC know. That's not voluntary. It also doesn't mean your third partner let OFAC know, and then you let OFAC know. Again, that's not voluntary. So when it comes to a situation like that, where there's a third party, it really is a fact-specific question. So this is a third party that you don't ever care about doing business with them. They're not, a partner that really makes any difference to you, that matters to you in terms of further business opportunities. Then, as to whether or not you provide them with notice, about voluntarily disclosing something to the government, that's really your own call. If it's a business partner that you really do hope to continue relationships with, they're a key business partner. In that instance, we do always recommend that it's worth the discussion with that business partner, because obviously if you're going to be disclosing something to the government, you're probably going to have to disclose their name in it, or what the item was. And so as a result, the U.S. government's going to find out that they have done something wrong. So the U.S. government will start to investigate them, and they'll lose that voluntary credit if they don't get it, sort of a notice in at the same time or around the same time.
Yeah, that's kind of what I was getting at. It just seemed like good business practice that, hey, we're going to legally impact these people heavily.
Yep.
They should know before, or at least at the same time, not afterwards.
Right. Yeah, no, and I think that the government can do what they like, but I will say that OFAC tends to be pretty reasonable. And so if you provide OFAC with notice, and a third-party partner had provided notice to OFAC a week before, 2 weeks before, it's still possible that OFAC won't give you that voluntary credit. They'll probably, if they don't give you that voluntary credit, they might mitigate you in other ways because you did still disclose it. Oftentimes, though, they're not going to be sort of that sticky with the, oh, well, they got it in a day before you, so they're going to get the voluntary credit and you're not. But I think it's certainly worth having that business discussion. I'm gonna come to this question, Akana, just because I know we had one other question, and then we'll, yeah. Okay, great. Did you?
So I just would like to say something. If you are an exporting company, I think it's very important that you pay attention to the documentation. Most often than not, the documentation is actually not, as an exporter, the document actually serves as your proof of shipment. So this is actually the bill of lading that is issued to you by your service provider. And you have to pay attention to the remarks that are in there, because the point of origin, point of discharge, and destination should be properly stipulated, so that when you actually export to China, then for instance, your China customer intends to sell it to a country that does not do any trading agreement with the U.S., then you can be not held liable. So, because most often than not, there are times when some customers would be selling it to another company outside China. So I think that is very important. And also, years ago, there was this syndicated system, which you call like the Twitch bill of lading, wherein when you sell to China, and then the bill of lading is actually revised so that it will show that the origin is not coming from the States, but that has been somehow discovered by the major carriers, and that one still exists, but it is definitely not legal. So just to let you know.
Yeah, no, the paperwork requirements are good. That's good. The EAR requires that you have a destination control statement. The ITAR has a similar statement, and so sort of combining something that sort of covers you there. And we have had a client where they've been involved with a re-export that went somewhere where it shouldn't, but none of their paperwork had that diversion statement in it. And so that's difficult to explain to the U.S. government that, oh, by the way, we didn't provide our foreign party partner with the right notice. So that's certainly a good point.
Just a comment. What we do in my company, Eric, is, I mean, NDA is one thing, but every contract that goes out of our company along the supply chain, the distribution chain, has clauses that say they have to comply with these laws. Back. Not only that, but it also maintains the record retention requirements under those laws and gives us the ability to inspect those records if we want to. And if we see a supplier or someone along our distribution chain that pitches on those requirements or asks, what is this? So us, that's red flag already. There's only so much we can do, but as long as we take steps to mitigate the risks and show OFAC or something like this is everything we did to prevent this problem. This was a complete surprise to us.
And do you guys actually ever enforce the audit rights on that, or do you only enforce the audit rights when it's in conjunction with something else, or what are your, how do you handle that?
That's a good question. I've been on the job for 45 days.
Okay.
So, I mean, that would be, stay tuned. Yeah, stay tuned. But I think that's it. I mean, you have your certification requirements. That's always an annual thing for us as well. Along with saying, hey, you're not on the SDN output. Of course, I always question who's going to admit that they're on the SDN. You know what I mean? But that's, again, the step we can show. Here's our homework, go back. You know what I mean? The government certification thing should be an annual thing for us. Now, the audit inspection rights, we have to look closer into the company's resources to do that.
Yeah, no, the certification, I strongly encourage, if you've got any sort of red flag, I mean, I think it's good business practice regardless of whether you've got a red flag, but if there's any sort of red flag, having that certification, that's sort of the bare minimum you can do to protect yourself. Yeah.
So just to follow up on my Eric's question and what Joaquin just mentioned, non-disclosure agreements typically address that the party receiving something shouldn't disclose information to another party, but they usually don't address export controls issues. So that's why earlier I talked about a duty to require and a duty to notify. I think it's helpful for all companies doing business with suppliers to inquire, are they export controls compliant? And in the process of doing business with them initially, to get them to either sign certification or to at least use destination control statements as higher measures in the documentation going with the products out to the vendors before they process them, before they use them, before they send the product to you to be forwarded to your product. At least you've notified them of their obligations. And as Joaquin said, you've done as much as you can to try to notify your vendors that they have obligations. And then that's part of your compliance program, to show that you've done as much as possible that you could, because you don't have control of what they're doing. But you can at least show that, you know, right, you notify them. And that's part of your compliance program.
The last question?
I was just curious, have you seen, these are civil charges or civil offenses. Have you seen examples of an actual criminal charge?
Yeah. So under all three of the sets of regulations, there are civil and criminal penalties possible. Like I said, OEE, which sits in the BIS at Commerce, is the only one of the sort of traditional export control agencies that actually has the power to enforce things criminally. On the OFAC side and on the ITAR side, DDTC and OFAC can enforce things criminally, so they'll always engage with the Department of Justice. And most often, OEE also engages with the Department of Justice if it's a criminal penalty. What I would say for people in this room is that if you're coming to an event like this, the chances of you ever disclosing something and facing some sort of criminal penalty is probably as close to zero as possible. I don't want to say it's not possible, but you know, if you actually are trying to comply with these laws the chances of you actually getting criminal penalties is pretty much next to nothing. It's really the individuals and entities that are very clearly trying to get something to somebody that they shouldn't, and they know that, and they know it's going to go into something that could potentially hurt U.S. soldiers or hurt U.S. persons or our allies. So it's really when you have that intentionality to get something to Iran for a weapons program that the U.S. government is going to sort of enforce the criminal side of things.